Tell me about the knife. Whose knife was that?
That was hers.
It was a folding knife, huh?
I suppose, yes.
Okay. Did you ever have it and threaten her with it?
No, sir. Because when the police went in, she had the knife. But she wasn't threatening me with it either. She was just in the kitchen with it.
Okay.
We are about to watch the parole revocation hearing of a man who had got the break of his life, one might say. Now, this revocation hearing has nothing to do with the case that I'll review with you at the end in the unpacking. But for the record, he was sentenced or found guilty by a jury for taking another man's life. And then right before sentencing, it came out that there may have been perjury on the stand, witnesses that lied under oath, and they ended up ordering a new trial, never getting that trial, and setting him free. Now, he couldn't take advantage of that because he committed more felonies, got locked up, and now is facing a revocation hearing. Will he get lucky again this time? Let's find out.
I am going to read some allegations against you for violating your parole, and you're going to enter a plea of guilty, not guilty, or guilty with a statement. You were arrested by the Calcasieu Parish Sheriff's Office on 5/21/2024 for the crimes of aggravated domestic abuse, felony, and false imprisonment, which is a misdemeanor. These charges were downgraded to criminal mischief misdemeanor, in which you pled guilty 7/16/2024. How do you plead?
Well, I did plead guilty to criminal mischief.
So you plead guilty to criminal mischief. Okay. Number 10, you've never made payments towards your fees, and you're currently $569 in arrears. How do you plead?
Plead guilty to that.
So you were released August of last year, is that correct?
Yes, ma'am.
We do have your sister, Shalitha Bertrand, who is joining us via Zoom, that would like to speak on your behalf, and we'll let her do that now. Yes, ma'am. Go ahead and just address us with what you want us to know.
Hello, my name is Shalisa Bertrand. I'm Shannon Bertrand's sister. And I just wanted to take this time and thank y'all for giving me this time to speak. And I was just speaking on my brother's behalf, just saying that he's a very loving person. He has children out here that needs him. He has a son that is a star player that's about to soon graduate that needs him home, a daughter. He's able to hold down a job, and he has a house that is still rent still being paid for whenever he is released. And Shannon, he helps my mom a lot. He helps us all out a lot. He's a very caring person. He helps with our children, his nieces and nephews. And we would just, hopefully he'll be able to come home.
Thank you very much for being with us, Ms. Bertrand.
Yes, ma'am.
At this time, Mr. Bertrand, do you answer questions by Mr. Freeman?
Okay, good morning, Mr. Bertrand. Tell me what went on. What happened? Why were you arrested?
Okay, it was the morning. Me and my girlfriend, we had a argument, a disagreement, and I believe the neighbors heard us arguing because we live in an apartment, and the neighbors, I think the neighbors, somebody called the police, Then once the police arrived, my girlfriend, she Hispanic, she could barely speak English. So when she was trying to explain to them, they don't know we were just arguing, and they couldn't really understand her. So they end up just taking me to the parish jail, and like about a month later, she ended up signing an affidavit form on my behalf. So that pretty much really that happened that really led to my arrest.
Okay, was
And
there a
I
knife
pled guilty
involved?
to.
Was there a knife
A knife?
involved?
No, I didn't have a knife. When the police came inside, she was holding a knife at the kitchen. And she ended up giving it to him. But they
Okay.
seen her with it.
Did you grab her by the arm and throw her on the bed?
A bottle. No.
Okay, was she trying to leave and you wouldn't let her?
When the police came, I was trying to tell the police I wanted her out, but she didn't want to leave. We was just like arguing behind the whole situation. Stuff that going on in the phone she didn't like.
That's not making sense according to the arrest report, because I mean, she sent emails to her church saying she was trying to get out of there and you wouldn't let her leave. So what's that about? I mean, she just made the emails up or what?
I don't know, like we was talking, and then I ended up telling her that I wanted her to leave because it's some stuff that she seen in my phone, and some stuff that we could just basically just arguing behind everything. So she seen stuff in the phone, and I wanted her to leave, but she didn't want to go. She didn't want to go because she wanted to continue talking about this, exactly what was going on. Yeah, so
Right. Would you not let her call her kids? Did you take her phone and wouldn't let her call her kids?
Did I take her phone? All right, at one time I did get her phone that morning because she was looking through my phone. So I'm like, let me look through yours because you looking through mine. So basically that's what happened.
Okay, well, so was her phone in your pocket when the police got there?
Yes.
And also, you tested positive for THC and PCP. What's that about? You using drugs again?
At one time I tested positive for PCP in September of last year, and after that I started a rehab. I started outpatient rehab center out here in Lake Charles, and I've been clean since.
And clean since.
11.
Okay. Where is she today? Are y'all still talking?
We still be talking. We talk. Matter of fact, I just talked to her last night. She was supposed to be here, but I don't know what happened. I just talked to her last night on the phone.
Okay, yeah, I was wondering where she was. That sure would help your case. Now, why you said you pled guilty?
All right, I pled guilty because my parole officer had told me if my charge get dropped down from to like a lesser misdemeanor that's not dealing with a victim, then I wouldn't get violated. So after she signed the affidavit, I was gonna wait. But once I went to court and they asked me if I wanted to fill out the criminal mischief, I just went ahead and did it because I didn't think I was gonna get violated.
You know, we sent a memo out, and that's what making me question that. We have told all parole officers, never tell you you're not gonna be violated, because you could be violated even with no charges, much less pleading guilty to a charge. You understand?
I understand. So,
Yeah, I have no further questions.
I'd like to address something you said to Mr. Freeman that doesn't seem quite right according to you went to an outpatient rehab in August, is that correct? Sir? You went to You went to outpatient drug rehab in August of last year?
No, I started in September last year. Oh, hold on, I ain't gonna, hold on. I went to an inpatient rehab in August last year. I put myself in inpatient rehab in August of last year, like a week after I paroled out. And then I started outpatient rehab in September last year.
And you had a failed drug test in November.
So it was September. I know November. No, right.
Okay.
I can't remember the date.
Why did you not report to the day reporting center? You were supposed to go to day reporting center and you never completed the intake.
You talking the reporting center, the mental health over there? Me and my parole officer, we had an agreement for me to go to the Imperial Health on Carmen Street, and I was going into my Medicaid, and it ran out. I had to renew my Medicaid.
Mr. Prater, do you have any questions?
Not much, but tell me about the knife. Whose knife was that?
That was hers.
It was a folding knife, huh?
I suppose, yes.
Okay. Did you ever have it and threaten her with it?
No, sir. Because when the police went in, she had the knife. But she wasn't threatening me with it either. She was just in the kitchen with it.
Okay. I don't have any questions. I think I know what's going on.
Okay, at this time, Mr. Freeman, are you prepared to vote?
Yes, ma'am. You pled guilty in court to the criminal mischief, which was a big break from the charges that you had pending. Not find you guilty of violating condition number 4 and number 10, and I vote to revoke your parole.
Mr. Prater?
Concur, yes, ma'am, I concur. That's all I'll say, 4 and 10.
Mr. Bertrand, I also vote to revoke. I think that you had a difficult time on supervision, and I'm not sure you've been forthcoming with the facts of the matter today. I find you guilty of number 4 and 10. You have been revoked today, sir. Okay, this is the 11:08, and we're signing off in Calcasieu Parish. Thank you.
You're welcome. So, bullish.
Well, I might say the same thing if I found out that I'd have to spend, I don't know how much more time in prison, but with the new parole laws, you have to serve up to 85% of your sentence before you can even get another opportunity. So there could have been a lot riding on this. Now, this is what I was, well, okay, before we do, and Sir Richard pointed out this note, how Mr. Freeman used to run probation and parole before becoming a parole board member himself. You know, it is amazing to me that we still see parole officers saying, hey, just take a plea deal. We still see attorneys saying, hey, just take a plea deal. You know, it's okay if you just take a lower plea deal, if it's not a felony, if it's a misdemeanor. And it's just not true. The parole contracts clearly states you cannot be involved in any criminal activity. It's the most vague language there is, period. Vague for a reason. And it's a contentious point, and that's why Sir Richard brought it up, and that's specifically wanted to show this hearing because of that statement made by Mr. Freeman. We sent a letter to all of our parole officers letting them know you cannot, that's not going to solve the problem. You cannot take a plea deal. And we're gonna see a bunch of attorney hearings coming up, revocation hearings, where again we see attorneys make these mistakes, and it's mind-blowing to me that it's still happening. We've been watching the revocation hearings since they started airing it in 2020, so it's 4 years of the same mistakes, and it's inexcusable. in my opinion, that it's still happening. But apparently, the Louisiana Parole Board acknowledges it's happening. That's why they even sent a memo. That's why the parole, to their officers, you can't accept any type of charge. So here's what Sir Richard found when he was initially found guilty of murder, and then having the sentence reversed, and then eventually the DA just dropping the charges because the case fell apart. And if you can imagine having that second chance at life and blowing it, Shannon Bertrand became a free man today after several years in jail awaiting trial for murder. The district attorney's office had dismissed charges against him for the murder of Marcus Mayo, but the DA says it's not over. Shortly after noon, Bertrand walked away from Calcasieu Correctional Center, where he was awaiting trial for the 2007 murder. Bertrand was once found guilty of second degree by Judge Wilfred Carter, but Carter granted a motion for a new trial, and now, as the new trial was to begin, the district attorney dismissed charges. But the DA, John DeRoy, says not because they think that they have the wrong man. We have absolute confidence in the initial investigation that the Lake Charles Police Department did in this case. We think they found the right man. We tried the right man. We convicted the right man for the murder of the victim. Prosecutors say that 4 or 5 witnesses in the case all lied in court. And DeRosier says the some may face perjury charges. We need people who come to court and tell the truth, as we encourage these witnesses to do exactly that. Unfortunately, that did not happen in this case. However, Bertrand's attorney, Todd Clemens, says his client is not guilty. I'm glad they finally had the courage of their convictions to do the right thing. I believe this is something that should have been done several months ago, if not years ago, because I don't think they ever had enough evidence to prove this man's guilt beyond a reasonable doubt. And that's what the prosecutor's job is, to prove cases beyond a reasonable doubt. They may have had a theory about what happened, but they never had proof beyond a reasonable doubt. He expressed doubt there is evidence to warrant reinstating charges. They have 4 years to investigate. Why would it take 4 years to investigate a crime that occurred reportedly back in 2007? So I don't think there's any evidence that they're going to find after all these years. Marcus Mayo was shot 3 times, twice in the back of the head, and his family, along with law enforcement officials, pled for those who knew the truth to do the right thing, come forward. Judge Carter reversed his guilty verdict last year, saying that he considered improper evidence. So whether he actually did it or not, it's still a second chance of life when you have something overturned and set free. And I guess he had gotten locked up again to have even been in parole on the first place. And, oh yeah, it's a folding knife. Oh, it's her folding. Everyone uses folding knives in kitchens. That's a good one. And there you have it.
If you've been watching this channel long enough, you would know how seriously I take my privacy. So when I saw in the news that National Public Data announced that they suffered a major breach, potentially impacting every American, that really blew my mind. They say that over 2.9 billion records that are used for background checks. This includes personal information like full names, address, date of birth, phone numbers, and social security numbers, that it's been hacked, and confirmed that members of the hacker group released this information online for free for everyone to access. Why they would do this, who knows? But when they're caught, when we cover their parole hearing, I hope that it's a resounding deny. Now, anyways, if you haven't been taking your personal information online seriously, I think now is the time to change that. We are more vulnerable than ever before with today's landscape. And thankfully, I feel secure with Aura, the sponsor of today's video. I've been using Aura for nearly a year now. I get an email in my inbox every week. I click into it. I get all the information right there. It makes me sleep better at night. And on top of it, they offer a $5 million in identity theft insurance for worst case scenario. There's a side quality of life improvement as well that I personally love. And that is that Aura has nearly stopped all spam calls. I used to get 6, 7 a day. It stopped. That to me makes it worth it in itself. If you want to give it a 2-week trial, go to the link in the description below, aura.com/Mandu. Please keep in mind that there will not be a drop-down option in the YouTube box that says Mandu, but it still will attribute to me if you use that link. Anyways, let's go back to the hearing.
Today we have for parole consideration Isiah Jones Jr., DOC number 132331, who's a first felony offender who was convicted of second-degree murder at a trial by jury on April 20th, 1990, and on April 30th, 1990, was sentenced to serve life in prison without the benefit of probation, parole, or suspension of sentence in Iberville Parish. Your parole eligibility date is August 1st, 2021. Your good time date is October 24th, 2037, and your full term date is March 5th, 2088. Does that information sound correct to you?
Yes, sir.
All right. So here it is. You get the first question. What did you do to cause your incarceration, and why do you think we should release you on parole?
What I did to come here was I was at a bar one night and drinking, smoking. I mean, out having a so-called good time, and before I knew it, it was drug dealing. I was off into drug dealing, and from there, it was a drug dispute between me and Mr. Lewis. And after that, I left, went to the house, and around about 3:30 a.m. or 4 o'clock a.m. that morning, I heard a scuffling in the house, and I got out of bed, and I seen in the kitchen was Lewis, my mom, and my stepdad, and then it was scuffling. When I came in and I seen what was going on, and I panicked, and I ended up picking up a knife and jugged Lewis, and which I am truly sorry for what I've done. And after that, it was like, wow, I seen Lewis run out the house. When he ran out the house, and my mom told me, see, it was just a bad dispute. I mean, I was full of drugs and alcohol. I didn't mean it at all. I just lost it. I was drunk and on drugs.
You should be great.
All right,
And-
let's get there. Now, what have you done to convince us to let you go?
Right now, why I should be released is that at one point in my life, I was like unmanageable. I was powerless, very uncertain of what may take place with me the next few minutes. And that's when I end up stabbing Mr. Lewis Tillman. I truly, deeply apologize to the Tillman family and for all those that I hurted in the process of it. But at this moment, I sit before you a changed person. And from all the required classes that I have taken, it has bettered me to become the person that I am today, to be able to be released back into society as a better person, and knowing all the classes that I took to help me along the way. Also that I am very fit now because I can think better, function better upon any kind of pressure or whatever. I can function better. I am a changed person now. From the life that I did when I took Mr. Tillman's life, I would never be the same person like that again. Right now, I'm ready, truly ready for society from everything I have learned and the skill setting in this prison that had taught me to become the man that I am today. I am a better person, think better. The classes helped me in numerous ways, and I am truly ready to be returned back into society.
Now we're gonna give Ms. Hutchinson a chance to speak.
Okay. And it's my understanding I won't be able to reserve my comments for the end today.
You wanna wait till last? I'll let you go last.
Thank you, Mr. Byron.
All right. How about the warden? Can you add anything about his conduct in prison? Or any comments you might have for him?
Yes, sir. Since being incarcerated since 1991 over here at Louisiana State Penitentiary, he has became a Class A trustee. He's got a total of 13 disciplinary reports. He has completed anger management and 100 hours of programs. Thinking for the change. He received a GED in 1995. He recently completed trauma healing, and he is currently enrolled in victim awareness. And if it's granted parole, I recommend that he complete that course before then. Thank you.
And which course we talking about?
Victim awareness.
All right. Today we have several people in support wanting to speak and several people just watching and not wanting to speak. So we'll start with. So we all, in opposition, we don't have anybody here, but we do have some opposition from the pre-parole investigation. The district attorney is opposed and the sheriff is opposed. Okay, and now Ms. Hutchinson, we'll let you go ahead.
Thank you, board. As the committee knows, I represent clients before you often, usually several times a month. And rarely am I ever able to present a picture as complete, humbling, and inspiring as this one. And this is honestly because of the tremendous step the Tillman family took, in which you heard from Ms. Wanda Thompson, in them initiating the victim offender dialogue. You see, Isiah was already doing well by most standards by 2013 before he met with Mr. Tillman's sisters. He had completed his GED, and if you look at his institutional record, which I have in page 6 of my brief, he had really aged out of his reckless behavior. He had earned some significant training. He had done the auto collision and repair, I think the first level of welding, and he had done library assistance and legal counsel to death row. He had done DOC programming to address anger management issues. So he was really already on the right track before that meeting. But I would be remiss not to highlight and spotlight what I had the absolute pleasure in learning from Isiah. And that is how the power of forgiveness pushed him and carried him and inspired him to continue on and truly be a better man, a brother, a father, and a friend. And I think that's evident by the amount of people that are there in support, right? He bettered himself and his family embraced him, and he worked hard. His humble, happy, and forgiving heart can only be the mirror of what he received from the Tillman family. He went on to take more programs like Thinking for a Change and Inside Out Dad, where he can be a better parent through, even though he was incarcerated, right? And so today we humbly ask the committee to see Isiah for what the Tillman family saw back in 2013 and what's present today, and that he's a rehabilitated man and a man that takes responsibility for the hurt and harm he caused. A man who poses no threat to society and who's been trusted within the prison and even outside the prison walls. One of the certificates in the brief is actually for doing the roughing work at the headquarters where you all are right now. So I mean, he's worked outside the gates. And a forgiven man, right? Who's being welcomed home by not only the extended family you see in front of you and here with us here, but also, as you've heard, he's been welcomed back by the Tillman family. This is an opportunity to acknowledge restorative and redemptive justice today. And so we pray that you see Isiah as the man he has spent 36 years building himself up to be, and grant him parole with any conditions deemed necessary. Thank you.
Thank you. All right, the case has been assigned to Ms. Stapleton, so you go ahead and ask the first question.
Good morning, sir. Do you want me to call you Isiah or Mr. Jones? What's your favorite?
Isiah.
Okay, Isiah. All right. Well, boy, you do have a lot of support. You do have a lot of support. So, you're a fortunate man.
Thank you.
Listen, I wanted to ask you something. I'm just gonna get into the crux of the situation. When you were talking, you said that there was a fight. He came to your house, and it was a drug deal gone bad. He was accusing you, you know, selling them bad drugs or whatever it was. But anyway, you said you stabbed him and he ran out. So he was alive when he left your house. Is that correct?
Yes,
So
ma'am.
tell me what happened. Did he, when did he die?
It is your, they said when they took him to the house, made it to his house, then they took him in the ambulance to the hospital. That's
Huh?
where he ended up dying in the hospital.
So he made it to his house.
Yes, ma'am.
Did y'all live close to each other or did he drive over to your house?
So we live right around the corner from each other.
So he walked over or something?
Yeah.
He walked over and then he walked back home and then they found him injured and then they called an ambulance and he died at the hospital, correct?
Yes, ma'am.
Okay. All right. How many stab wounds did he have? Do you know?
To my understanding, I really know it was one that I knew of.
Okay. I was just wondering, they weren't able to find the police report that happened at that time. So, you know, there was some holes in everything. So, I think that's the best I can do with those questions. Your GED, that was very important for you to move forward in life. Your GED, you got that. And now let me ask you, if you were to leave out of there, what job would you pursue? Because I heard him say collision repair and then a welding. What is it that you think you'd pursue if you went to an employer? Which type of employer would you go to?
I would go back to welding.
Welding, okay. That's an excellent profession and it's in great demand. I've got some nephews and uncles that are welders. Okay, now let me ask you this. Why are you so late taking the victim awareness course? What's going on there?
Well, because at first they said by me having the victim dialogue that I didn't really need it. So now that it has enrollment in it, and that's why I didn't get into it early because I had to took the victim dialogue.
Well, since the victim dialogue has come up so many times, what caused you to want to be with the victims and talk to them and everything? Tell me what your perspective on that was.
Well, at first when they came to me and let me know that the victim wanted to meet with me, I was honestly kind of afraid because I didn't know how it was going to turn out.
Right.
And the two ladies that was over it came and spoke with me for a week and explained to me how things was going to go. And then they asked me, was I willing to do it? And I said, yeah, I would do it. And when we did it, the first time I met with the Tillman sister, it was like, it was so hurting because I didn't think it was going to go that way.
Yes.
I mean, they took and they accepted me. They forgave me for what I did. I never had that in my life. And they took me in and told me they love me and forgive me for what I did to their brother. And through that made me become a better man, even in prison. I never ever experienced anything like that for the victim family to take and forgive me and accept me after the hurt that I caused their family. And from that point, I ain't have no other choice but to do better by me. I wanted to become a better man from that. Because if they can forgive me, I can forgive myself and move forward. That's why I'm so thankful of the Tillman family, because they didn't have to, but they did it for me. And now I am the man I am today through what they helped me with. And I appreciate it and I love them for it.
It's a powerful program. I graduated from that program. I was a facilitator. And the funny thing was, like you said, you were first afraid. The offender that I met with, one of his questions to me was, they're not allowed to hit me, are they? I said, no, you can't do that. You know, he was going to do it, but they didn't want to be hit, you know? So it is, and we normally, this is not something that's brought up, but since it is, it's all over the place in your record. So I was going to bring it up and find out what you thought about it. Now you did hear the warden. he would like for you, well, no, he requested you finish that victim awareness program before any release. You heard that.
Yes, ma'am.
And you heard the opposition, DA, sheriff, but of course you, on the other hand, you have strong victim support, the Louisiana Parole Project, but you got strong family support too. Those things are very important. And you served 36 years, you're 59 years old, and you're gonna get out anyway. Am I correct on 2027, Mr. Knox? Is that correct? Did I hear that? 2037. Okay, because I was going to say, gee whiz. Okay, well, all right. All right, well, that's the end of my questions.
Mr. Renata, do you have any questions? I don't have any questions. Are we ready to vote?
And if I may, I know, Ms. Stapleton had asked about employment. So, Louisiana Parole Project has an employment enhancement department that should be able to bridge his certification in welding from here to the outside. And his stepbrother has talked to his employer about employment. So we do have that in place. It is in the brief, but it's kind of towards the end. So I did want to make sure you all were aware that we are proactively working to bridge it once he gets out so that he can begin employment immediately.
Oh, that's wonderful. Okay, thank you very much for that information.
You're welcome.
All right, Ms. Stapleton, case is assigned to you.
Okay, well, today, because of all the things I just stated, that you have the strong victim support, the strong family support. You have a future with your welding. I don't believe you're no longer a threat to society, but sometimes that's the case anyway. But the family, I mean, I read, and I think it's important that part of our mission is that we address the needs of the victim, and then also that we ensure crime victims have a voice in the decision-making process. So based upon that too, that wouldn't be the only thing if I thought you were a threat to society or something. But because of that, my vote today is to grant your parole with the condition that you do finish the victim awareness program.
Renata?
Mr. Jones, Ryan, to the Tillman family, thanks for being here. You were here in 2019 and just listening to what Isiah said, you know, Isiah changed your family's life forever. But you changed his life forever. And here we are today. Isiah, I voted for you back in 2019, long time ago. And for the same reasons I'm voting for you today, I vote to grant you parole to the Parole Project plan after you finish victim awareness.
Mr. Jones, I usually vote against a case like this. Mr. Hutchinson and Mr. Myers can tell you all day long I vote no with strong victim opposition. But today I'm going to vote to grant you parole. And I'm going to warn you that should you commit any violation whatsoever, I will easily revoke your parole for the 99-year sentence. So don't even think you can smoke a joint or hang around somebody who's smoking a joint or anything. You go out there and you prove to us that what you're telling us today is true, and you will have a successful, free rest of your life. You go out there and meet any old buddies and do old things, you're gonna be right back where you started from, and I'm gonna be the first no vote. But today, your parole has been granted. Congratulations.
Good luck.
Thank you, board.
Oh, man.
Okay, so let's unpack this. Remember, this is part of the governor's 56. We made a playlist down for it below. The governor commuted 56 inmates in the last 3 months of his term. So check the playlist. It's called The Purge, the governor's 56. You know, this one, I'm glad that if they would have denied, I think they'd be crazy, right? This is clearly, I'm actually curious, and we'll go over the appeal, how he was convicted of this charge. A man broke into his home, right? Like, how do you get convicted? A man broke into his home at 1 o'clock in the morning. I mean, that's my understanding of skimming through it. We'll read it together. I don't, like, because if okay, anyways, the next thing that pisses me off, Sir Richard put it in the notes. They're making him finish a victims awareness program. Literally, he met with the victim's here on his behalf. Like, you don't need to attend another program. No. The warden says it blindly, and then the parole board blindly says, okay. And it's just stupid. And I just, those type of things piss me off. Sir Richard put it in the notes. And actually, it's been like a trend. There have been a lot of hearings where the warden is just blindly saying it. And it's just, there's some agenda there's some, it's a money thing. I'm sure of it. It's just my opinion, but you got to put people in the programs, and it is a money thing because you got to pay it. It's a blah, blah. Anyways, so let's go. I'm happy. Oh gosh, we don't see him again. How many parole or commutation parole hearings that we have seen where it's in like fast forward 2 years, and here they are back in front of us. And we do cover that. It's called The Return Of. Check out that playlist, The Return Of playlist, if you want to see those who we see multiple times. The reason we don't have his commutation hearing, otherwise we would, is because he was commuted all the way back in 2019. So you have to think about it. Sometimes when you see these commutation hearings, it took him 5 years from his time he was commuted to getting a parole hearing. So also keep that into perspective. I think when Kerry Myers was first commuted, for those of you who don't know, Kerry Myers killed his wife and brutally harmed his young infant child, and then actually had this most bizarre story about how it happened. Such a bizarre story, they made a TV show on it, because he basically said that he and his buddy were fighting with each other for like 15 hours, like a Family Guy episode, in their living room floor. And then they stopped to drink beer because his buddy was sleeping with his wife. And then the whole story was just like a joke. And then Kerry Myers served all this time, and he got commuted and then had to wait like 8 years to get released. And he was released. Anyways, I've done a few episodes on it, so I don't need to go into detail. Let's go over the appeal. Also interesting about this appeal is that his mother, there's a second appeal, but his mother initially took blame for it. Initially said that she's the one that stabbed him, and she ended up getting a 10-year sentence for that. So this event changed everyone's lives in a huge way. May 22nd, 1992. Isiah Jones was charged with second-degree murder in violation of blah, blah, blah. He pled not guilty, and after a jury trial was found guilty as charged, he was sentenced to life imprisonment at hard labor without the benefit of parole, probation, or sentence. Can you guys... Oh, whoops, I'm on the wrong one. I was sharing the wrong one. I'm glad I checked. The trial court erred when it allowed the prosecutor to impeach his own. This is what he's saying now. He's saying these are the 8 reasons why I should get appeal. The trial court erred. Let's read the 8th one because it's relevant. The trial court erred in not granting the defendant motion for a post-verdict judgment or acquittal, alternatively rendering the judgment, modifying the verdict, and rendering a judgment of conviction on the lesser included response of manslaughter, which it just seems like manslaughter to me. But okay, we'll go through it. Not even. It actually seems like self-defense. But okay, again, for the 18th time, let's go through it. Facts of the case. At about 4 a.m., so not 1 a.m., 4 a.m. on September 12th, 1988, police officers were dispatched to the home of the defendant's mother, who had called to report that someone had broken into her home. Officers arrived there and interviewed Mrs. Jones. She's the one who got the 10-year sentence, who gave an oral statement that the man had broken into her house and that she had fought with the man. At about the same time, police received a call that a man had been stabbed and was located a short distance from Jones' residence. This man, Luis Tillman Jr., the victim, was the man who had entered Mrs. Jones' home. The victim had been stabbed 3 times, by the way, so that's when Miss Stapleton asked how many times. He said, I don't know, which was, by the way, an interesting response. He would know. Not necessarily he would know because he was there, because I get people forget, but he went to trial. He's appealed it, so that was interesting. But hey, we had more info than the parole board, right? And subsequently died. The defendant was arrested for murder. At the trial, Terry James, defendant's girlfriend, testified that about 1 a.m., she and the defendant were in their bedroom when they heard someone calling the defendant's name. After the defendant left the room, Ms. James heard the defendant struggling with someone. Ms. James then heard Arthur Jones, Mrs. Jones' boyfriend, and Mrs. Jones leave their bedroom and enter the kitchen. Ms. James also went into the kitchen where she saw Arthur Jones, Mrs. Jones, the defendant, and the victim who was running out of the house. Ms. James saw blood on the floor, on defendant, on Arthur Jones. She further testified that the defendant told her that she had stabbed. The defendant told her that he had stabbed the victim. Ms. James recalled that the defendant was bruised and red on the night of the stabbing from being hit by the victim. In her trial testimony, Ms. James admitted giving 2 prior statements to the police, one on the day of the incident and another statement 2 months later. Ms. James admitted that she related different versions of the incident in her statement to the police. In the first statement, she said that Arthur Jones, Mrs. Jones, and the defendant were struggling with the victim, but did not say who stabbed the victim. The second statement was as follows. Ms. James stated that she and the defendant entered the living room when they heard voices. There, she saw Arthur Jones and Geraldi Jones speak to the victim. In response to the conversation, the defendant stated that he did not have the victim's money. So the defendant stated that he did not have the victim's money. The defendant left the room and the victim followed him into the kitchen. Miss James also left the living room and returned to the bedroom. After hearing a struggle in the kitchen, Miss James went to the kitchen. She saw Arthur Jones and Miss Jones struggling with the victim. The defendant, she said, was standing off to the side near the stove. She saw blood on the floor and the victim running out the door. She also saw a knife in Arthur Jones' hand. Arthur Jones told the others to just say that the victim broke in for some money. So he never broke in. He was invited in. Is that what it is? Mrs. Jones told the defendant to say nothing, that she would say she did it. And she's just like, don't say anything. I'll say I did it. Look at that. You know, all they had to do again was say, attorney. And they'd have nothing. But it takes a true crime, I guess, person to really know that. Who else would know that, right? Officer Donald Ray Bradley, Sr. of the blah blah Police Department, testified and investigated that the complaint of the Jones residence on the night of the incident, Ms. Jones stated that the victim broke into her house and she stabbed him. Officer Spraley did not observe any bruises or marks on Ms. Jones. He also saw the defendant come out of the bedroom and did not see any bruises on the defendant. Detective Napoleon Dotson of the Plaquemine Police Department testified that there were no signs of forced entry into the home, nor did he see any visible bruises on either Mrs. Jones or the defendant on the night of the incident. At the trial, Mrs. Jones testified that she had given 2 statements to police after the stabbing. In the first statement, Ms. Jones stated that she, not the defendant, had stabbed the victim during a struggle in her kitchen. In that statement, she said during the night, she left her bedroom when she heard someone kicking her door. When she entered the kitchen, she saw the victim and he started fighting with her. Ms. Jones grabbed a knife off the counter and stabbed the victim twice. When the defendant and his girlfriend came out of their bedroom, the victim ran for the house. Ms. Jones then called the police. In her second statement, Ms. Jones stated that she was in her bedroom when she heard a loud noise. When she entered the kitchen, she saw the defendant fighting with the victim and heard the victim yell, "Get the knife." She tried to stop the fight, and the victim grabbed her by the throat. After a struggle with the victim ran out of the house, Ms. Jones turned on the kitchen lights and discovered blood and a knife on the floor. Ms. Jones and the defendant were covered in blood, but realized neither of them was cut. After mopping up the blood on the floor, she called the police. However, during the trial, Ms. Jones related a third version of the incident. Oh boy. She stated, and again, remember, this is mom, like, She stated that at about 11:30 p.m., a few hours before the stabbing, the victim knocked on her door, asked for the defendant, and stated that the defendant owed him some money. Ms. Jones told him that the defendant was not at home. After some disagreement as to whether or not the victim could wait on Mrs. Jones' porch, the victim stated that he would wait at the corner and that he was going to kill him, the defendant. When I see him, then Miss Jones asked him to come in to discuss the matter. She offered to give the victim some money if he'd agree to leave her son alone. The victim agreed. He accepted the money and apologized to Miss Jones for his behavior. Later, when the defendant came home, Miss Jones confronted him about owing money to the victim. Miss Jones also told the defendant that the victim had threatened him and that she had paid the victim. So that's a third story, but then had the later that night, Miss Jones came out of her bedroom and saw the victim, whom she later recognized as the man who had been looking for her son. They struggled, and the defendant, hearing the noise, came out of his bedroom. Miss Jones was pushed against the wall, and the victim lunged at the defendant. They fought, and the victim began hitting and beating the defendant. She screamed, and Arthur Jones came out of the kitchen and broke up the fight. Seeing the blood, she checked to see if either she or the defendant was bleeding. Neither was cut. She further admitted that the first statement was false and that she gave it because she was trying to protect her son. I want to know what the prosecutor's story claim happened. Okay, so here's his story. In his testimony, the defendant stated that he had seen the victim earlier on the evening of the stabbing. The victim asked the defendant to obtain some Pepsi. The defendant answered that he did not know if he could do so. Then the defendant went to a lounge until approximately 2:30 a.m. When he returned home, on the way home, he again saw the victim, who stated that he had been to the defendant's mother's home. Once the defendant returned home, the defendant's mother told him that of the threat that the victim had made against him. The defendant then went to bed and later heard someone calling his name. He got up and saw his mother and the victim struggling in the kitchen. The victim pushed his mother away and lunged after the defendant. The defendant was continuously beaten by the victim, who was holding the defendant with one hand and striking him with the other. As to visible injuries, the defendant stated that he had a hickey on his forehead as a result of the fight. That's funny because the defendant also stated that he had previously heard the victim had been convicted of a violent act upon a person and that he had been sent to an anger management program. The defendant admitted that he gave conflicting statements. So they claimed that the defendant was that the door of the house had a window pane that previously had been broken and that anyone could reach through and turn it without the key. So they're saying, so there was no forced and they're claiming that that's how it was open, but we know there was no forced entry. It's just interesting. I still wonder how you get convicted of this crime. The man's in your house. And I guess, we don't have this story of what the prosecution claimed, right? But I'm guessing it would have had to have been that they claimed he invited him into the house and then there was a confrontation. That's the only way it could have been. Here, and the evidence establishes that the victim was unarmed when he began fighting with the defendant and the defendant's mother, that no bruises or injuries were visible on the defendant or his mother by the police officers who investigated the homicide shortly after the fight and stabbing, and that there were numerous versions of the stabbing incident related by the defendant. That would have been the nail on the coffin. 4 different stories. His mother and his girlfriend, obviously the jury chose not to find that the stabbing was committed in self-defense or that in heated passion required for finding a manslaughter. Viewing the evidence in light most favorable to the prosecution, we find that a rational trier of fact could have found beyond a reasonable doubt that the defendant was guilty of second-degree murder. The assignment of error lacks merit. I disagree. How do you guys feel about this? I disagree. You could be in a fight with someone and not have a bruise. The guy shows up. He's pissed off. It's like, what, 3, 4 in the morning, and he can like shove you against the wall and you grab a knife and stab him. I mean, that's self-defense. He could have stuck his hand, opened up the door, and I just disagree. Like what you're stating, why would he Sir Richard mentioned something in the spreadsheet. Let me see what it is. So he says, interesting ruling that SCOTUS voiding majority rule isn't retro in LA and dissent. So there is some type of appeal that I guess SCOTUS got involved in. Here it is. I don't know. Court of Appeal for Circuit. This was in 2020. Wow, it was recent. So a judge was applying for supervisory writs. Rule set. So frankly, I'm not law tube enough to know what this means. So anyone watching who wants to let me know in the comments section, if you can read it. I'll hover it over a little longer. So, but I don't get it. How do you get second degree murder in this case? You would think that no matter, like, you would at least get the lesser charge. But now so they screwed up with their stories and all that, and they obviously weren't believable and all that. But yeah, just goes to show you never know with these things. And there you have it. But it's just an interesting case in general that the family was so forgiving, and that's something that is, I mean, just truly unique. And I know that I fast forwarded through the supporting comments. This entire hearing outside of my unpacking was 20 minutes. So I added a whopping 20 minutes, which was pretty obnoxious. But the supporting comments were like over 10 minutes. So it would have been a third of the entire hearing. And I just don't think a lot of you would have sat through it. The difference is with my unpacking is I do it at the end. So any of you who don't want to sit through it, you just bounce out. So that's why I can ramble. Anyways, with that, I'll let you go.
The offender that I met with, one of his questions to me was, they're not allowed to hit me, are they? And I said, no, you can't do that. He was going to do it, but they didn't want to be hit, So
Tell me about the knife. Whose knife was that?
That was hers.
It was a folding knife, huh?
I suppose, yes.
Okay. Did you ever have it and threaten her with it?
No, sir. Because when the police went in, she had the knife. But she wasn't threatening me with it either. She was just in the kitchen with it.
Okay.